Hello again, Judge Courier.
Hi, Ashley.
All right, so we're just waiting for Sabatino and Gooden Brown, and then we are good to go.
Okay, great.
All right, thank you.
Thank you.
I see Judge Courier is with us. Judge, can you hear me?
Yes, I can hear you.
Yeah, the camera is focused above your head. Maybe we tilt it down a bit. Mr. Kott, I see you in the picture. Can you see all of Judge Courier's it's cut off? I couldn't hear you, Mr. Kott.
Judge Sabatino, I can see all the judges, Your Honor.
Okay, you see the way my screen is portraying it. My colleagues feel like I'm cutting them off all the time, so. I see Judge Gooden Brown. I think I see a circle for her. Are you back, Judge Gooden Brown?
I'm here.
Fantastic. All right. So let's see. We have Amicus counsel on with us who's going to argue.
Yes, good afternoon, Your Honor. Daniel Rogers.
Okay, I saw Mr. Slater before. There he is. All right, so, and Ms. Kabash, is she back yet?
Yes, I am. Thank you, Your Honor.
Okay. Any of you have any problems seeing us fully? Apparently not. Okay. All right, so back into our Zoom world, folks. This is docket number A1083-18, Mary and Thomas McGinnis against C.R. Bard and other defendants. Counsel for the appellant, first, please enter your appearance, Mr. Kott.
Good afternoon. My name is David Kott, K-O-T-T. My law firm is McCarter & English, LLP, and I'm the attorney for defendant appellant C.R. Bard, Inc.
Right. And Ms. Kabash, any re-enter your appearance on now, recognizing that this argument on 510K also extends to the Tharaimot case we heard this morning. So please enter your appearance at this stage.
Thank you, Your Honor. Maha Kabash for Danzig firm on behalf of the defendant appellant Johnson & Johnson and Ethicon, Inc.
Right. And you yielded much of your time to Mr. Kott on the 510K thing.
That's correct, Your Honor, in light of a lot of the overlap of the legal issues.
Right. Good. It made sense to do it this way. And Mr. Kott, I want to make it even. You get 12 minutes, not 11. I know you're overjoyed to hear that. Mr. Slater's with us. I want to enter your appearance as well.
Yes, Judge Adam Slater on behalf of the plaintiffs in both cases.
All right. Mr. Rogers, please. And your appearance.
Your Honor, can you hear me?
Not that time, not too well.
Okay.
I can't see you either. Have you suppressed your camera?
Can you see me now, Your Honor?
Got you now. Yep.
Yeah, I had to switch cameras. My apologies. My technology failed, so I'm going on the backup, and glad you can hear me. Thank you.
Yeah. All right. Glad to have you with us. All right. You get 10 minutes. And then we've already mapped out the time. We've got a lot to talk about this afternoon. Mr. Kott, you're going to go first, right, on the 510K issue?
That's correct, Your Honor.
All right. And you did get the court's advisory about abuse of discretion, et cetera, right?
Yes, and I'm going to address that, I promise, Your Honor, and the other judges. In about 4 minutes in, I address that, Your Honor.
All right, until I interrupt you at minute 2, and then we get all diverted. Okay. Please proceed, Mr. Kott.
Your Honor, may I reserve 5 minutes for rebuttal at the very end of the argument?
Yeah, and I announced that to the staff. Yep, you got it. All right,
Okay.
So the clock begins. 1:35. Go ahead.
In this court's opinion, in Kendall versus Roche, this court said, quote, "The hallmark of our system is fairness," close quote. We find that same concept in Evidence Rule 102 and New Jersey Court Rule 1:1-2, both of which instruct courts that in construing the rules, they should construe them to ensure fairness and a just determination. That also appears in the case law in New Jersey, and I'll give you one example, the opening the door doctrine is based on fairness. In this case, the plaintiff on 23 occasions referred to the defendant's lack of clinical testing. The plaintiff said clinical testing was required. The plaintiff said clinical testing was necessary. The plaintiff said that because there was not clinical testing, these products were experimental. The plaintiff offered the testimony of the treating physician, Dr. Barbie, and she testified on the warning issue that she was deceived by Ethicon and actually was allowed to give the opinion that in her opinion, Ethicon acted unethically. Here's what Ethicon wanted to offer. I'm sorry, I kept referring to Ethicon, I meant Bard. Here is what Bard wanted to offer at trial. And it's reflected in the long proffer. I'm not going to go into the proffer, but this is what we wanted to offer at trial. That Bard submitted a comprehensive 510K application on every aspect of the product: design, manufacture, and warnings. Bard's 510K submission also included information on testing of the products and specific information on the safety and efficacy of the products. We know that the FDA reviewed that because they instructed Bard on one of the products to change the warnings. And the FDA, in granting the 510K clearance, and what I'm going to now say comes from the FDA's own records, not from Bard's records. The FDA, in granting the clearance, said two things. First, the products were safe and effective. And second, that clinical testing was not necessary or required to demonstrate that the products were safe and effective.
Let me stop you right there just to clarify what you just said, Mr. Kott, so I understand the specific of the proffer. Is if the 510K clearance evidence had been admitted, would the defendant agree that the plaintiff could allow the jury to know that the FDA, upon receipt of your company's submission, advised that certain things needed to be changed? Would the proffer? Okay, all right. That's helpful to know. Thank you. You may move on.
And then, of course,
You can finish your sentence if you want.
And of course, the board changed them because without changing them, the FDA would not grant clearance. Judge Currier.
Yeah, so a lot of the decisions that we've read where the evidence issue has been looked at all around the country, initially a judge and then many others have parroted it, that this would cause a mini trial, would cause confusion. So how, if BARD and Ethicon were permitted to follow through on your proffer and to admit this evidence, how is it going to be done?
Well, it's going to come in, and there are two aspects to your question. One is confusion, and one is, I think, delay. On confusion, there's not going to be confusion. Most of the cases I think Your Honor is referring to talk about, well, the jury's going to think that that's the end of the analysis. And that's easily dealt with both under North Carolina law and under New Jersey law, because both states have a model jury charge going specifically to the FDA evidence. And I'm referring in New Jersey to New Jersey Model Jury Charge 5.40D. And I'm going to paraphrase it, but that model jury charge says something like, ladies and gentlemen, you've heard testimony about the FDA in this case. That is only one factor that you should take into account in deciding whether the defendant acted reasonably in designing and warnings. That's only one risk utility factor. Ladies and gentlemen, I'm instructing you that, in fact, you can still render a verdict against BARD if you find that they did not act unreasonably. That's the way to, and there's a lot of cases more recently that admit the evidence.
Right, and that tracks, and what you just said tracks the suggestion in Weinberger.
Yeah, it does. And I'll, Judge Sabatino, can I come back to you and answer the second part of Judge Carrier's question?
Absolutely, yeah.
About delay. You know, I come back to the wording of 403, and it's bizarre. I'm talking to three judges who dealt with it as trial judges all the time, but the word is undue delay. Here, this is not some tangential issue. This is an issue that is a core issue in the case. Are the products defective? And we know it's not going to take that long because in the BARD IVC filter MDL, there were 3 trials that took place where this evidence was admitted. And those 3 trials all concluded in 3 weeks. And the trial judge has another weapon in her arsenal here. And that weapon is putting time limits. Say to the defendant, I'm going to give you whatever's reasonable. 3 weeks to put on your case. So I think that deals with undue delay. It's not undue, and it would be completely unfair to use undue delay as a way to eliminate the factual defense of a defendant in a case like this, because that is in effect what it would do.
Right, but as, in a number of the cases that have denied admission of the evidence, that's been the language that's used. It would be a mini trial within a trial, et cetera. So my question was, who did you intend to use to put this evidence in? Was there an expert regarding FDA procedures? Was it just somebody from the in-house that was going to explain it? That's what I was curious about.
I'm sorry, Judge. Okay. It's largely the expert, Dr. Tillman. She's the FDA expert. She dealt with these issues at the FDA, and it may be supplemented by a company witness as well, but it largely comes in through the expert.
Okay. And so presuming that you would be able to explain the procedure of 510K, either you or do you agree that if you did not go further with it, that plaintiff would certainly then be able to bring in information regarding the pre-market approval process and the differences?
Yes, the plaintiff could surely cross-examine the expert and say, well, there's another way of doing this that apply to other products. We couldn't use the PMA. We were not, because it's a class 2 device. Right. So we were not allowed. But I think it would be a fair cross-examination for the plaintiff to say, well, the FDA for medicines has a different way of doing it. And for certain devices, medicines are new drug application, other devices are pre-market approval, and that's more rigorous. And in fact, she was questioned extensively in her deposition on that, and I would think that would be fair game for the plaintiff at trial.
And then again, of course, if the court gave the limiting instruction that we saw in Weinbarger, then that would take away from a lot of the back and forth between the parties on the procedure.
Right, and Judge Creer, I would just say that the procedure is a little complicated, meaning this question of law, the admissibility of the evidence gets pretty complicated. But what's coming in is not complicated.
Right.
It's what I said before. Sabatino, I forgot the question. I promised I'd come back to you.
No, maybe you understand how this all unfolded with these two trials and two different judges anyway. But Judge Hars in pretrial said you're not going to be allowed to the company can't put in the 510K evidence. But then it looks like Judge DeLuca made an independent finding to say it turned out to be the same result. But what if they had differing views? Is the standard of review, and this, Mr. Slater, I'm sure we'll have to address this, is the standard of review under traditional evidence doctrine here abuse of discretion? So if it's a call balancing 401 versus 403 could go rationally either way, we defer, or is this one because it's a mass tort case? I thought these pretrial in limine rulings were agreed by the plaintiff side and defense side to be handled consistently from trial to trial, but yet we have this independent ruling by Judge DeLuca that potentially could have gone the other way. I don't understand how we review this situation through that prism here. What's the appropriate way to look at it in a mass tort context?
Sure. Two-part answer, and hear me out on this, Judge. The first part is on the standard of review, we contend in McGinnis that it's de novo because the basis for his ruling was his interpretation of the federal code, the CFR, and the guidances by the FDA that clearance does not equal safety. So that he made a legal determination. He also made a legal determination as well on the interpretation of the North Carolina statute that he did not need to instruct the jury and the risk utility factor on any government standards. So we don't think it matters, though, on this record, Judge, because even if you go to abuse of discretion, here there was an abuse of discretion because there was manifest injustice, and I'll point you to three cases. This court's opinion in Kendall, which I mentioned before, this court's opinion in McCarroll versus Roche, this court's opinion in Rosetto versus Roche, three mass tort trials that involved highly discretionary rulings of the trial court, and this court reversed under an abuse of discretion standard, saying that it was a manifest injustice. Second part, Justice Sabatino, you're asking me what's the story on an MCL? We're going to slow down a little. Judge Hars in Ethicon, in the Ethicon MCL, after the Supreme Court in New Jersey decided the second Accutane decision, the one on choice of law, she ruled on a motion of the plaintiff that going forward, New Jersey substantive law would apply to all trials, irrespective of where the plaintiff came from. And under New Jersey substantive law on design defect and on warning, the Supreme Court said in the Feldman versus Letterly, the second Feldman decision, and under Perez versus Wyatt, that it's very similar to North Carolina law. We look at the reasonableness of the conduct of the defendant, and in those cases, the Supreme Court specifically stated that a defendant's meeting the FDA requirements was admissible on the question of whether the defendant acted unreasonably. On top of that, we know going forward, plaintiffs are going to argue lack of clinical trials on whether our conduct was reasonable. We know that, and I've got objective proof for that, because that's what they argued heavily in the three MCL trials that have taken place. Gross, Heimrock, and this case, McGinnis. And it's more important and clearer to me on punitives that, in fact, the 510K evidence always is admissible. And it's admissible for two reasons. First of all, on punitives under the New Jersey Punitive Damage Act, we look at two things. We look at state of mind and we look at conduct. Well, state of mind, the fact that we made decisions because we wanted to comply with what the FDA required goes to our state of mind. On conduct, the fact that we didn't do clinical testing and that the FDA told us that clinical testing was not required to demonstrate safety and effectiveness clearly is relevant on punitives. And one final thing in response to your question, Judge Stefano. If FDA evidence and complying with FDA regs is admissible in compensatories, going to the reasonableness of the defendant's conduct, as the Supreme Court held in Feldman and Perez, to me, it is a compelled, logical, and legal conclusion that it should be admitted on punitives. We're going to admit it on the reasonableness of the conduct on compensatory, on design defect, and on warning. I don't see how across all of the pelvic mesh MCLs it's not coming in on punitives. Judge Gooden-Brown, I've got more, but if you've got a question for me, I'm ready for you.
Well, I was speaking to Judge Currier's question. What you described as the plaintiff's cross-examination, doesn't that underscore the point on the undue delay and the mini-trial, the 403 concern? How you just described what the plaintiff's cross-examination would be?
I do not think it does for the reasons I stated before, Judge Gooden-Brown, but I can tell you it's my understanding, and I don't have this on personal knowledge, but it's my understanding that, and again, the more recent decisions have allowed this evidence in. It's my understanding that the 510K evidence was a relatively short portion of the trial. We're talking, and I'll switch the hypothetical. You know, in a medical malpractice case or a product liability case involving a snow thrower, we have experts on both sides. And in the malpractice case, the experts talk about the standard of care. In the product liability case, the experts talk about the products. And that's one portion of the trial, but it doesn't eat up the entire trial. And the analogy, Judge Gooden-Brown, is in the snowblower case, the defense expert would say, well, it met these three industry standards. And the plaintiff would say, well, that's a minimum standard. You could have done more, right? You could have done more than the industry. Well, that's analogous to, well, there's another way of doing this. If it were a medicine, it would be more rigorous under a new drug application. If it were a different kind of device, it would be more rigorous under a pre-market approval. I don't see that as chewing up a lot of time, particularly these trials typically are 6 and 7 weeks when you look at the percentage of trial. And as I said before, I don't see how consumption of time can be used on an issue that not only is not tangential, but is the core issue in the case, particularly when the plaintiff runs down the field with nobody allowed to chase him on 23 times, stating no clinical testing, and having the treating physician, and this is the treating physician, a crucial witness, saying, I was deceived and they acted unethically.
We're speaking of time. We've hit that point, Mr. Kott. Let me find out, Ms. Currier, at this point, do you have any further questions of Mr. Kott?
Just my one question I had, and I'm just searching through my piles, but it didn't appear to me, I'm looking at the two orders that are on review, so the eliminate, and it doesn't, and I guess I'll wait for Ms. Kabash on this, but it doesn't look like Judge Hars ever did a 403 analysis. at least in her ruling in the order, correct? She just compared it to the fact that it wasn't a pre-market approval process, and so it couldn't be presented because it was not approved by the FDA as safe and effective.
Yeah, Your Honor, I can't speak to the Ethicon order just because I don't remember, but I can speak to what in his
BARD order, right?
In the BARD order, and there was extensive oral argument on the motion in limine, and in the trial judge's opinion on the motion in limine at the time, what he said was what Your Honor just said, that Judge Horst said, well, this is not pre-market approval. I view that as a non sequitur. Yes, it's not pre-market approval. That says nothing about the admissibility of the evidence.
Well, his order actually said exactly what her order said.
Right.
Actually, right? Now, he had an oral decision where he talked about the prior cases, the cases that Judge Goodwin had done. He just refers to those, and he finds it's not a government standard under the North Carolina law. And then he just sort of says in one sentence, even though I thought the process had some probative value, its probative value is substantially outweighed by the prejudice and confusion. But there's no further elaboration on that, and there's nothing in an order regarding that. The 403 weighing, correct?
That's correct. In fact, in our brief, we called his oral opinion after the trial conclusory. I mean, it's as Your Honor characterized it.
Okay.
Any further questions, Judge Currier, of Mr. Kott right now?
Not right now.
All right. Judge Gooden-Brown, anything else you want to ask counsel?
No, I just like the football analogy.
We're not going to talk about Tom Brady. I said that earlier. All right. Let's move on, Ms. Kadash, on the 501K, 510K.
No,
that would be a very long race, by the way, a 510K.
Yes, and not one that I'm interested in participating in, Your Honor.
Right.
I hope you can hear me well.
Yes.
Yes, we're good.
Okay, great. Certainly let me know if that stops being the case. I hope we've solved our previous technical issues. Your Honor, thank you. And I just want to start by saying that defendants Johnson & Johnson and Ethics Inc. Agree with and rely upon the arguments made by Mr. Kott on behalf of BARD with respect to the 510K admissibility and the other legal arguments that are present in both of our briefs. And so I won't bother the court with those so as not to be duplicative. But one thing I would like to focus on is the notion that it goes beyond what 510K means to address the admissibility of the evidence as it reflects the reasonableness of the conduct of the defendant, which I think is really quite a critical issue because that affects whether there is a level playing field in the parties' ability to tell their stories. And I think that concept of being able to tell your full story is exactly what was at the heart of Your Honor's rulings in McCarroll 2009 and Kendall 2010 that Mr. Kott already referred to. Here in the Frymont case, the defendants were not able to tell their full story and had their hands tied behind their back by Judge Parks' 510K ruling. And you are correct, Judge Currier, that in the Frymont case, it was a 402 relevance ruling and did not appear to go into a Rule 403 analysis. I'd just like to, in my limited time, provide the court with some examples of how this played out in our case. And I think it's important, apropos of what Mr. Kott was saying, that this is an issue that transcends all of these cases. And it's not because a particular plaintiff's lawyer makes a particular allegation or has a particular style. These issues are endemic to the claims themselves. When you make a design defect claim, this prompts the plaintiff's lawyers to say what's wrong with the defendant's conduct in their decision-making. This prompts the defense to be able to need to be able to say, this is what steps we took, this is why we made the decisions we made, this is why our actions were reasonable. So while a particular tactic or approach on the part of the plaintiff's lawyer may impact the extent of the prejudice, the exclusion of that evidence, I would say the nature of the claims themselves are what make it relevant.
So you're arguing a categorical position, though. I think both you and Mr. Cotter categorically say, regardless of what the words of the statute say, categorically this should always be allowed. This is not, as in Rodriguez versus Walmart, where the Supreme Court said, well, the 403 analysis is case by case. We're not going to declare a categorical approach. The defense wants a categorical approach. They want to be able to rely on any more of these trials that this will be within the constraints and with limiting instruction. This is coming in. You want a categorical decision, right? You don't want it to be up to the next judge that gets one of these to do a weighing, right?
Your Honor, I think that it should be reviewed de novo and would be a broader ruling. To the extent that the trial court's ruling is based on a misapplication of the law, that either 510K doesn't mean safety or efficacy, or that the evidence is not relevant to the defendant's reasonableness in complying with government relations, if that is a legal ruling and it should have universal application. And to the extent that the 403 analysis is tied to that misapplication of the law, it should also be reviewed de novo and have a broader application. I could see where there could be some cases where the evidence is actually admitted. And, you know, maybe the issue is, did the court's limiting instruction go too far, or was there not enough of a connection to a particular case? The fact pattern of that is not coming to me right now. I can see where that might arise. But I think based on the way that these cases are tried across the board, the nature of the claims that the plaintiffs make and the nature of the defenses we need to make, the ruling should have a broad application. Yeah.
Now let me ask you something that I'm sure all the defense attorneys in this case would have a view of, and while I have you, I'll ask you. The 510K clearance process is controversial. It's been criticized even by a blue ribbon panel, right? That we ought to just abolish it because it doesn't really achieve the objectives that was set out to do originally. It's too easy. It's been used too frequently. You've seen those criticisms. We've seen people from the industry say that's overblown. It's actually fairly rigorous, and we've been cited to the nooks and crannies of the regulations that the FDA applies and the data about how many times it sailed through the first time and all of that, right? But it is controversial. Given that controversy, is it safer or better to not get the jury in the weeds on that, right? Because it is a matter of fierce debate about whether it's rigorous at all. Or would you just let the jury hear both sides of that debate?
Your Honor, I think this is where I go back to, reminiscent of Mr. Kott's comments that regardless of whether it's fiercely debated, there is a relevance to the defendant's compliance with the government regulations, regardless of what they are. Obviously, we are arguing that 510K means safety and effectiveness for the reasons set forth in our brief. But even if you set that aside, whatever 510K means, the fact that the defendants here, Ethicon and BARD, complied with government regulations is still relevant to the analysis and still should come in.
And in your case, remind me, did the plaintiff likewise argue, maybe not 23 times, but did the plaintiff argue they haven't done a clinical trial, ladies and gentlemen? That shows that they're unreasonable, reckless. Was that same argument made in your case?
Absolutely, Your Honor. And the fact's a little bit different. I would be happy to actually show you 3 examples of how that manifested in our trial. First of all, we were not permitted to argue, first of all, as Mr. Kott mentioned, that the FDA nor Congress requires clinical trials in all 510K settings. Number 2, in our particular case, our 510K review lasted many months, involved several submissions of evidence, including a clinical study. In our 510K review, the FDA requested clinical data, and Ethicon provided the 1-year data, TVM data that Mr. Slater referenced in this morning's argument, that was on the ProLift prototype. And the reason why that's important, and the FDA's receipt of that and review of that is important, is because when Mr. Slater's expert, Dr. Ann Weber, criticized that data for not involving the ProList tools, we were not in a position to say, but the FDA reviewed that data and did not have that same criticism. Similarly, when Dr. Weber also criticized that data because that trial, just very briefly in the weeds, involved two wings, an American wing and a French wing. In the French wing, the data came out with slightly higher prolapse recurrent rates than what the high standard of the study defined to be success. She went to town with criticism on that particular issue and argued that that study was unreliable for that reason. We did not have the ability to say, that study was sent to the FDA and they reviewed it, they analyzed it in detail, and they did not have that criticism. This is the same type of evening the playing field that Mr. Kott referred to before in McCarroll and Kendall, even though I know that was a different factual context. It's about whether you get to tell your full story. So yes, it is the same type of question. Sometimes, if you don't have a clinical study, the plaintiffs are going to say you should have had one. If you had a clinical study, they're going to tell you the 15 reasons why it wasn't good enough. But it's the same type of attack, even if the nuances of it are a little bit different from case to case.
Judge Currier, you have any questions of counsel?
No.
Okay.
No.
Judge Gooden-Brown, anything you want to ask Ms. Kadesh?
No, thank you, Judge.
All right. Thank you very much. Let us hear what Mr. Slater has to say about these things. 510K.
Thank you, Your Honor. Thank you.
Thank you.
Thank you very much, Your Honor. I think that everything that we just heard really is a good example for why this evidence was appropriately excluded. And you only have to look as far as 3 federal courts of appeals that have looked at this, who are overseeing the federal MDL of over 100,000 cases, where they heard exactly these same arguments. These are not new arguments. And with an understanding of the breadth of this litigation and the complexity, said you're not going to be able to cloak yourself in the FDA to say that what you did was safe and effective. We understand that because that's not what the law says, and that's actually to say that you were approved by the FDA as safe and effective would be misbranding. So defense counsel says the core issue in the case was 510K, and without that, they were fighting with 2 hands tied behind their back, and they couldn't defend the case. Nothing could be further from the truth. And you heard some things that unfortunately aren't accurate. The first thing that Mr. Kott said is that the FDA found the devices to be safe and effective. The FDA doesn't make a finding of safety or effectiveness on 510K. It makes a finding of substantial equivalence, and I'm going to illustrate that for this panel in a few moments. He also said that clinical testing was not needed to show the product was safe and effective. I wrote down the exact words. And that's not true either. That's not what the FDA found in either of these matters. What actually happened is, and I think that a good place to jump off to show the complexity of what would happen at a trial with this is 1567A is the site to the McGinnis Appendix. And what this is the document that Bard gave to Judge DeLuca when they asked him to admit the evidence and they made their proffer. He said, what's the best evidence you have? And they gave him this document to say this is why it should be admitted. And he then carefully reviewed this document. And what it is, it's the actual checklist and finding by the FDA, their internal memorandum. And I'll point the court to a couple of things in here that I think will, A, show that 510K is not what you've just heard it is in terms of its breadth, and 2, you'll see how confusing and complex this would be. And that the entire...
before you do that, counsel, and I'm not sure... my question when I was reviewing this all through the weekend is there ever been a record before any court of someone producing this evidence and the other side counteracting it? I mean, you're about to tell us, but it wasn't in your trial, but you're about to tell us why, something about the procedure. I mean, has there ever been a record that anyone's ever made of that? In none of these cases, as from what I could tell, nobody's ever granted a 104 hearing on this.
Well, I'll tell you, there are cases outside of the consolidations where the evidence was received, and I'll give you an example. The Shearer case in Missouri was a state court case. It was a one-off case filed in state court. It was in state court because the doctor was also sued in that case, so the case could not be brought in federal court.
Right.
And on page 17 of our brief, we got the PowerPoints that were used by Bard's defense counsel in that case, who also defended this case, so that we could show the court what would happen if the case was tried this way. And you'll see on page 17 of our brief, and it's at PA 1987 to 2046, these are quotes from the PowerPoint. These are all quotes. FDA led the way. FDA cleared the Align, safe and effective. The FDA reviewed the Align device for safety and effectiveness 3 times, found it to be safe 3 times. All 3 times determined no additional testing was needed. So that trial, which lasted, I believe, 9 weeks, my understanding and my knowledge, because I know the people that tried the case, it was about the FDA. The entire defense kept coming back.
Right, but I mean, that can be controlled by a trial judge. I mean, this should be literally, I think I could explain both sides of this. I think it was Judge Harz's case, and you'll tell me, but she commented upon the intelligence of her jury, right? I think when she was ruling on the post-judgment motions. I think you had an attorney, a pharmacist. She listed out a number of people. And it may have been when she was looking at Remedial or new trial, whatever it may be. But I know I had, was speaking about this case and thinking about both sides, and it seems to me that a trial judge could keep it very, very limited to really what I was asking of Mr. Kott, where the procedure is explained, and then you would say, yep, but that has nothing to do with, they are not approving the safety or the effectiveness of this product. That's the pre-market approval and so forth. But it seems, I guess my question is, so you have this intelligent jury, and certainly in this kind of case, that's what everyone's looking for. And particularly in this world and this day and age, everyone knows about what FDA approval is, right? We all hope and think right now that our drugs and vaccines and everything else undergoes FDA approval. So if you try a case like this and the jury never hears a word about government being involved or the FDA, aren't they left scratching their heads in the jury room and asking themselves, how is that missing? How did the defendants just jam all this through and get to market it and make money? That's my concern about it.
Okay, and it's a fair question. I'll tell you what happened in these trials. The jurors are told, we did an extensive voir dire with questionnaires and then meet with each juror individually.
Sure.
And they're actually asked about their attitudes towards the FDA, and we're told at the outset of each trial, the FDA is not going to be something you're going to be considering in the course of this trial. It's just not something that's going to be dispositive of the issues. It's not something you should be concerned about. You're being asked these questions so we can find out more about you as a juror. So the jurors are every juror was told, you don't need to be concerned about the FDA in this case. So it wasn't that there was an elephant in the room. It was addressed, and the judge said it's not something you have to think about. You're being asked questions that don't require you to think about that. The jurors in both cases were told that.
And why is it relevant, though? I'm sorry, Judge. You're saying it was walled off, but that's an artificial wall if it's relevant. What makes it irrelevant? It's certainly not a direct assessment of safety and effectiveness. We understand that because it's an indirect effort to compare this particular product that's going through the 510K clearance as a Class 2 to something that's already been approved and gone through a more rigorous thing. So indirectly, doesn't it bear upon safety and effectiveness? And in fact, in the regulations that govern 510K, that phrase comes up in a number of places, and including the possible need, as here, where the FDA can demand a clinical trial. Why isn't this relevant to the reasonableness of the conduct of the party here? Because lawyers all the time in plaintiffs' cases, other plaintiffs' cases, they want the jury to hear about OSHA standards, right, and other government processes. So why in this setting do we say that this is irrelevant? Or is your position that, well, it's relevant, but it's just under 403, just unmanageable?
My position is this, Your Honor. First of all, there is not a court that has ever found that the 510K process is a safety process. Even the courts that have admitted the evidence have said this is not about safety, it's about substantial equivalence. So that issue's been, I believe, has been soundly addressed. Now,
as part of, hold that thought for a second, but as part of substantial equivalence, you have to show that your offered product is as safe and effective as the thing you're comparing it to. No?
What you're doing is you're finding you have to make a presentation on a very, very thin group of documents, and I'll address what Ms. Kabash said earlier because it wasn't exactly how it went down with them, but I'll get to that on Ethicon with the Pro List. What the FDA looks at is this substantially equivalent? For example, in the document that I was talking about, which is the actual checklist where the FDA went through this, on page 1584A, paragraph 6, discussion of labeling adequacy. The entire finding is the product labeling is equivalent to predicate surgical mesh labeling. So there's absolutely no analysis. And more important, Your Honor, and I want to make sure this is very clear, the predicate products were not CMA products. They didn't go through it. The entire chain goes back, and ultimately the chain goes back to grandfathered products. So the predicates in these cases with these products went through the same process where they went through the 510K process also. And so if you ask, okay, is it relevant? I will even, for this purposes of this argument, concede there is a very marginal, very slight relevance in the sense of it's something that the defendant did. I don't believe it proves anything. One of the arguments that was made is that it would show that the defendant acted reasonably. I don't think that it proves anything other than they filled out a checklist, they got the right to sell the product. All the evidence that the defendant wanted to put in each of these trials, they had the right to put in, other than saying we got 510K clearance. And I think really to help to illustrate why, in response to Judge Currier's question, limiting instruction is not the answer, I think the Weinbarger case is very helpful because, again, that's the root from which all the IBC filter cases also sprung. The initial decision and all the others followed that case, and it's a very puzzling case because, number one, the judge found that 510K clearance is not an applicable standard under the North Carolina statute. That was the finding the judge made in that decision, and Judge DeLuca agreed with that. Then the judge said that it may have minimal probative value. This is the decision that the defense is hanging their hat on, a case that says minimal probative value regarding, in this case, it was Boston Scientific, the Uphold device, same class of products. Minimal probative value regarding their efforts to adhere to FDA processes and procedure generally. Because, again, all 510K is a process. And then the judge said, however, the risk of misleading and confusing the jury is also great, and a mini trial will be a waste of time. And then, now I'm at where Judge Currier was.
Yeah.
The judge says admissibility might depend on a limiting instruction. And listen to what this judge says the limiting instruction is going to say, and put this whole argument in the context of this. This smart jury, what are they supposed to do with this? Being told that 510K clearance is not to be considered as evidence that the FDA authorized the Uphold in that case, that's the name of the product, as safe and approved its intended use as such, and that 510K clearance is not evidence that the manufacturer satisfied any standard of care in designing the device. On one hand, and Judge DeLuca squarely addressed this issue, it's on page 16 of our brief, citing DA 2258, that where he said even if the court were to find that there's some probative value, he found it was heavily outweighed by the prejudice and confusion, and said the court considered whether a limiting instruction would cure the issue and determined such limiting instruction would only further confuse the jury. So it's listening just to what you're hearing from us, and I'm going to go through to the extent until the bell rings to show you what would have come in, because I have evidence in the record I want to make sure that this panel sees. When you put that evidence through the prism of this type of a limiting instruction, it would be colossally confusing. And there's no way for a jury to be able to assemble that information in a case of this complexity because, again, looking at, the document that Bard proffered, and it's similar to what was filled out with the ProLift, at the end of the process, on 1584A, paragraph 9, the final question, analysis of the equivalence of the subject and predicates. It says, The device is technologically, safety, and effectiveness-wise substantially equivalent to predicate surgical mesh products indicated for repair of prolapse conditions. So now they're going to put in front of the jury things that say, quote-unquote, safety, and we're going to now, through experts, fight about, well, it doesn't mean safety in the sense of they evaluated safety, because the answer is they make a finding that it's substantially equivalent, and there's an assumption that's a minimal standard or minimal level to meet. So the entire trial, every single time I would open my mouth, you would hear, well, the FDA said they didn't need clinical data, as Mr. Kott said, to prove safety and effectiveness. Well, on page 1568A from the appendix, there's one question about clinical data. Was clinical data necessary to support the review of this 510K, which is to find substantial equivalence? They said no. That was the only consideration of the data. Do we need data to figure out if this Avolta product is similar to the Ugitex product that's the precursor 510K product they're piggybacking on? And what that tells you is absolutely nothing about whether clinical data is needed on the safety end, because they don't look at that. So looking at the line of cases from the courts of appeals, and these are courts of appeals spread around the country, the Fourth Circuit, the Seventh Circuit, the 11th Circuit, some seeing the issue multiple times and asking the U.S. Supreme Court to hear exactly this question, all saying, in the context of these cases, their expert's going to say, the FDA, if they didn't think it was safe, they don't clear it. And then I have to then cross the expert, well, this isn't what the document says, and their expert says it's not. And by the way, then I have an expert. And then the proffer includes that they want to put on witnesses. So there's going to be regulatory witnesses in the company, so we're going to fight about it with them. And they're going to want to put all of this evidence in, as I've just read to you, and there's another proffer on page 35 of the defendant's brief in this case, actually page 35 of my brief, I believe, where the defendant made another proffer of what they would have done in this case. They wanted to tell the jury virtually everything Bard did was motivated by the extensive FDA legal and regulatory framework. I mean, this is so misleading. There's no limiting instruction that can handle this. Most lawyers cannot handle this. It's so complex in terms of, well, is it safety, is it not? Why isn't it safety? Why is it substantial equivalence? Bard followed a path hewn by the FDA, etc. So coming back to what we're looking at on this appeal, these are evidentiary decisions on an abuse of discretion standard. Even if a member of this panel might say, well, I might have wanted to let it in with a limiting instruction. That's not enough to reverse these decisions by the judges.
Do you agree? Let me stop you. I still don't understand how Judge DeLuca ended up looking at it a second time. What's the purpose of selecting these so-called bellwether cases with in limine determinations made that would shorten the process for getting the next one teed up for trial? So I don't understand why the second judge made an individualized determination and whether the normal rules of the road apply on deference, because you could easily have conflicting decisions.
The reason it happened is because there were two MCLs, and they were both assigned to Judge Hars, and for a period of time, she was recused from the Bard MCL. So Judge DeLuca was assigned for the Bard MCL. So when that case came to him, that was the first case after, 10 years of the MCL or 9 years of the MCL hanging around. We finally got a case to trial, and he ruled for the Bard MCL, and Judge Hars had ruled for the Ethicon MCL. So I think that explains.
All right. But you want, as the defense, you want an affirmative statement by this court that this stuff in any of these pelvic mesh cases is barred categorically. You want that to say it's not up to the personal discretion of how the 401, 403 is pitched to the next judge, right? You want us to say this never comes in New Jersey in these cases, right?
In an MCL, in the pelvic mesh MCLs, where the facts of the pelvic mesh MCL, yes, I think so. I think that's the right outcome. That's how it was done in the MDL, or at least that's how it was envisioned.
Okay.
All right. Weinbarger aside, it's hard to understand how that happened, but those are remands in the federal system. But certainly every case Judge Goodwin tried, every case that he was involved in, that it was within the MDL when it was tried, the one ruling controlled. And what happened was some of the cases, if you're wondering, were tried in Florida. he went and sat by designation, so that's why they ended up in the 11th Circuit on a couple of those decisions.
I won't pretend to figure out the mystery of federal jurisprudence at this point. All right, thank you, Mr. Slater. We've heard enough about that. Let's move on to Mr. Kott again for the other arguments.
Your Honor, may I proceed?
Yes, you may.
I want to first address our argument that under Section 5 of the Product Liability Act, punitive damages are not recoverable as a matter of law. And I think I'm going to go back to law school and state what the issue is. The issue is when the legislature in Section 5 used the words approved, licensed, and generally recognized as safe, did they intend those words to have the same meaning as in the federal FDA statutes? Or did they intend those words to have the plain meaning? And I think the answer is found in the last sentence of Section 5, the very last sentence. And that sentence says, and I'm going to paraphrase it, in this section, the terms device, drug, food, and food additives have the same meaning as set forth in the FDA federal statutes. The legislature did not say that approved, licensed, and generally recognized as safe have the same meaning as in the federal statutes. And I think that is outcome determinative, but there's about 5 other reasons why we prevail as a matter of law under Section 5. If you adopt the plaintiff's interpretation of Section 5, it would mean devices would never have the protection of Section 5. And the reason I say that is in the record, it is shown that 99% of the devices are cleared through the 510K process. They're not pre-market approval. They're not generally recognized as safe. They're not licensed. There is about 1% that are approved through the pre-market approval process. But under the United States Supreme Court opinion in Regal, those cases, that 1% could never be brought because of federal preemption. In addition, the plaintiff's interpretation of the statute would mean drugs never, ever get the protection of Section 5 because drugs are not subject to pre-market approval, licensing, or generally recognized as safe. Drugs are approved through a process called the new drug application, totally different. So we think it's plain meaning on those words. Plain meaning of approved means a sanction to do something. Here, the FDA allowed Bard to sell the products. License, under our case law, means permission to do something that is otherwise unlawful. Here, it would have been unlawful for Bard to sell the products without the FDA clearance. Generally recognized as safe. In the FDA's own documents for these 2 products, it states they're generally recognized as safe. And more broadly, when these types of products, I'm talking generic surgical mesh, were put in Class 2 by the FDA, the 3 scientific panels that recommended that found that they were generally recognized as safe because surgical mesh had been used for a long time. 2 additional points on Section 5, and they're important points. The Product Liability Act does something that I think is somewhat unique. It states specifically that in interpreting the Act, the court should look to the legislative history. The Act actually says that. And when you look at the Assembly statement for the Product Liability Act, and you look at the governor's past bill memorandum, both of those state that Section 5 applies for products, quote, regulated, close quote, by the FDA, which these products clearly were. And we know what the legislature was doing in the Product Liability Act, and Ms. Kabosh referred to this earlier. But the legislature was trying to rebalance the law on product liability, and in part to protect, and I'm saying this out loud, this was their intent, to protect manufacturers of devices and medicines, because we're here in New Jersey, that we sometimes call America's medicine chest, where the largest employers and the largest corporate taxpayers are the large pharmaceutical and device companies, and the legislature didn't want them doing what everybody's always concerned about, is move to North Carolina for a more friendly litigation climate, or Florida, or Texas. Finally, on Section 5, the Act does something else that you don't often see. The Act specifically says that it's a remedial statute. And we know that remedial statutes are liberally construed. And in fact, the New Jersey Supreme Court has said 4 or 5 times in Roe, in Zaza, in Kendall, interpreting the Product Liability Act as it relates to pharmaceuticals and devices, that it should be liberally construed to effectuate the legislature's intent to reduce the exposure of pharmaceutical companies, particularly to punitive damages. So for all of those reasons, we believe that the judgment of the trial court on punitive damages should be reversed as a matter of law and should be remanded to the trial court to enter judgment as a matter of law on the punitive damages case. If, in fact, Your Honors disagree with our interpretation, we still believe that the punitive damage verdict should be reversed for the reasons I stated earlier. Let me also address, this case is governed by, or was tried under North Carolina law as far as the compensatory damages. The North Carolina Product Liability Statute says on the risk utility factors that the trial court shall, that's the word shall, the charge or instruct the following risk utility factors. And it lists 7 or 8 or 9 of them. One of those is any government standard. The word any is used. Other states, for instance, Texas, in statutes and in case law, limit things to any government safety standards. Here, the plaintiffs are asking, and the trial court granted their request, to amend the North Carolina statute to not be any government standard, but to be any safety standard. Now, we contend it is a safety standard. And the reason we contend that is when you look at the Safe Medical Devices Act of 1990, of 2000, which we call it, what does it do, the modern FDA Act. That act specifically says that the FDA, in doing clearances and granting clearances, shall consider safety and efficacy. That act required the FDA to require manufacturers to do patient registries and testing, and required the FDA to issue something called guidances, and I'm going to come to guidances in a moment. So Congress told the FDA, you issue guidances on this. We look at the Code of Federal Regulations. Same thing as I just said about the federal statutes. I'm going to add something. The Code of Federal Regulations have specific requirements for labeling and warning of devices.
Let me stop you there. Please. Okay. Some of those regulations which were cited by you or your Amicus colleagues were not in play in this matter. As the plaintiff's brief pointed out, Mr. Kott, there are different pathways under those regulations in terms of the rigor that's involved. And I understand the briefing was attempting to give us, the whole general scheme, but some of the checks or restrictions that have been cited in the briefing here were not actually the provisions in particular. Looking at page 16 of the plaintiff's response to the amici, and they highlight that 21 U.S.C. section 360 C as in Charlie 1, Roman numeral 1A, little 2 was not in play here, but rather little 1, which is involving whether there's the same technological characteristics. So it is, I think, not very precise to point to the whole body of federal regulations and say, aha, they're all rigorous, because in this case, this was pursued under a subsection 1 and not a subpart 2. Am I wrong factually about that?
I think factually you're correct. However, Your Honor, if you'll hear me out on this, the FDA guidances, and the FDA said this 3 or 4 times over a number of years, clear as a bell, that in every 510K application, they consider safety and efficacy. And my rhetorical question, it's rhetorical because counsel does not ask questions of the judges, is why in the world would the FDA say that if it weren't true? But on your precise question about same technological characteristics, they're comparing it to predicates. In our case, meaning McGinnis, the predicates were 2004, 2005, 2006. After Congress enacted the Safe Medical Devices Act of 2000, beefing up the clearance process. So here, the 3 predicates had been examined for safety and efficacy. And there's one additional point on this. The 3 predicates had been out in the market. And I think, as Your Honor knows from some of the other pharma decisions that you participated in, under the federal regulations, the manufacturers have a legal obligation to report what we in this trade call AERs, adverse event reports, to the FDA. So the FDA had the 3 predicates that had been out there for a number of years. It had approved them as safe and effective, but beyond that, they had been out there with a proven history of safety and efficacy based on the lack of AERs.
Okay,
so,
continue.
Okay, so so that's Weinberger. On the question, let me come back to Weinberger for a moment. Weinberger is the only North Carolina decision that addresses this. And our state Supreme Court has said that if you're going to apply the law of a different state, you must apply the statutory construction rules of the other state as well. In Weinberger, like this case, it was a pelvic mesh case. In Weinberger, like this case, the plaintiff filed a motion in limine to bar the 510K evidence. In Weinberger, like this case, the plaintiff made the exact arguments that Mr. Slater made below and that he makes here. And the one North Carolina judge who's confronted this issue ended up saying it's admissible because it goes to the reasonableness of the conduct. But coming back to my colloquy with Judge Currier earlier, but I, as a North Carolina judge, recognize there might be a chance for some confusion, so I'm going to give the appropriate limited instruction. I think as a matter of comedy, I don't know whether, and I confess I don't know the law, I don't know whether you're positively bound by the Weinberger decision, as you would be by a decision in the New Jersey Supreme Court. You might be under the New Jersey Supreme Court choice of law decisions. But even if I'm wrong and you're not bound by it, as a matter of comedy, it seems to me that if a North Carolina judge interprets the statute and rejects the very argument being made here that you should follow that. I would suspect the judge in North Carolina, if this court reached a decision and he or she were required to apply New Jersey law, she'd say 3 judges in the Appellate Division in New Jersey found this. And I'm going to use colloquial terms, that's good enough for me. I'm going to give credit to the 3 judges in New Jersey because they live this stuff every day.
But what about a federal district judge?
Well,
you're asking us to defer. Am I wrong? Weinberg is a federal district judge. Right?
And I am. And
why should we wait, hold on a second. Why should we give greater deference to that federal judge who's likewise not a state court judge that's part of the development of state law?
Yeah, I think the logic is the same because he sits in North Carolina every day and he applies North Carolina law. And I'm going to refer to another District of New Jersey case. We have the Seavey case decided by Judge Kugler in the District of New Jersey. Seavey was a medical device case, and it's cited in our brief, medical device case. And in Seavey, Judge Kugler found that it was approved, meaning back to the language of Section 5. Now, I guess Judge Sabatino, in your colloquy with me, you would say, well, we're free not to follow Judge Kugler. But that's a little bit different because Judge Kugler is applying New Jersey law. The federal district judge in North Carolina sits there every day applying North Carolina law. And I would think, again, I don't know that I'm suggesting you're bound by that, but I would think there'd be heavy deference paid to that.
Judge Currier, do you have any questions of Mr. Kott at this point?
I don't, thank you.
Judge Gooden-Brown?
No questions. Thank you.
Thank you. Thank you, Mr. Kott.
Thank you, Your Honor.
We'll see if we need any rebuttal time later. All right. I think we're now up to, how did I set this up? I think, is it Mr. Slater, is it your turn before the amicus, right? Or are you after? I think you're after the amicus.
After.
Yeah, after, right? Because you get the opportunity to sort of sweep in to your response to what he may have to say. All right. So let's hear from our amicus. Thank you. Mr. Rogers, you with us?
Yes, good afternoon. Can you hear me, Your Honor?
Very well. Thank you.
Okay, great. Yeah. In my history of pandemic oral arguments, this has been my first technological snafu today. So hopefully everything's good from here on out. Thank you. Thank you very much. May it please the court. Daniel Rogers of the law firm of Shook, Hardy & Bacon. We thank the court for accepting our brief on behalf of our amici as well as the other amici and inviting us to participate in the oral argument today. We concur with the defendant excluding the evidence of these medical devices.
Mr. Rogers, we now have had another glitch. You froze.
Can you hear me now?
Yeah. We'll let you know, but we lost about 2 sentences.
My apologies, Your Honor.
You froze again.
This is literally like my 10th one, and I apologize for the first time. My apologies, Your Honor. Maybe I can call in?
I prefer not.
Can you hear me now?
Yes.
Okay. I'm trying to shut down everything, every other. I've closed every other program on my computer. I apologize.
All right, you want to try?
Okay. Try again. Can you hear me now?
Yeah.
Okay.
So
okay. I see a very strange screen, but I'm going to keep talking until you tell me otherwise. All right. Sorry, judges. So we concur with the defendants here that the trial court erred in excluding the evidence of these medical devices 510K clearance. It's particularly true here because of the punitive damages that were at issue in this case. Particular substantive law of North Carolina and New Jersey, that's that issue. So there's 3 points that the amici want to emphasize here with the court today. First, that the evidence of governmental standards that govern a manufacturer's conduct and the manufacturer's compliance with those standards is highly relevant evidence that has always been admissible in courts of this state and around the country. And I believe you even heard the plaintiff admit that in his argument, that that type of evidence of compliance with governmental standards is relevant to the reasonableness of a manufacturer's conduct. And this is particularly important when you're dealing with a substantive law that prescribes conduct based upon unreasonableness, and evidence of a manufacturer's compliance with a governmental standard is certainly highly relevant to that, as well as to punitive damages issues. The second point we would like to emphasize has to do with the government standard specifically at issue here, which is the 510K clearance process. That evidence is highly relevant in this particular type of case. And contrary to what plaintiff has told you, both the statutes, the regulations, and the experts over at the FDA have all explained that 510K clearance is a determination that there is a reasonable assurance of a medical device's safety and effectiveness. And then the third point that we would like to emphasize has to do with the significant policy reasons that require the admission of this evidence. Principally, we look at the careful balance that's been struck by both North Carolina and New Jersey product liability and punitive damages law that state that this type of evidence regarding a manufacturer's conduct is highly relevant and admissible. And then at the same token, you have situations where you have FDA determinations that can protect patients and provide reasonable assurance of safety and effectiveness. That is the policy balance that the legislatures have struck and that the courts should enforce in these particular cases. Now, based upon the court's questioning earlier, it seems like one of the issues that is troubling the court, and I'm happy to answer any questions. You know, I've been involved in these kind of cases in various areas throughout the country. But it seems like one of the issues that was troubling the court has to do with how this evidence might come out in a trial and whether or not, you know, it might become an unnecessary feature or take too much time. And I can tell you, judges, that that's not the case. We know from empirical experience that we can have limits that are appropriate on this type of evidence. We know the Weinbarger case actually went to trial as the Carlson case in North Carolina. Right? That case went up on appeal to the Fourth Circuit as well. It did not involve an appeal of the 510K issue. However, if you look at the trial transcript in that Carlson case and you see what happened with the FDA evidence in that case, well, the judge gave the appropriate limiting instruction that is articulated in the Weinbarger decision. And then there was evidence that was admitted in the trial regarding the FDA clearance of the particular device at issue. And if you count up the number of lines of the transcript that the FDA evidence took up in that particular trial, it was less than 3% of the trial. Right? So we know that if there are appropriate instructions, appropriate limits put on the evidence, this is something that can be tried appropriately in courts of New Jersey, in courts of North Carolina, and courts everywhere.
Can I stop you there? Can you hear me, Mr. Rogers? I'm sorry. Yeah.
Absolutely.
In terms of what is appropriate, does your organization and the other amici endorse the PowerPoint slide and presentation that was proffered here as indicative of what is appropriate and how it should be pitched to the jury? Or did, in fact, that proposed PowerPoint and a presentation go overboard?
Yeah, and if I believe what we're referring to and what plaintiff's counsel was referring to was a PowerPoint that was used during the Scherer trial in Missouri. If that's the particular PowerPoint that's being referred to, I can tell you that that was a particular case where I believe he was either I think Judge Currier or Judge Gooden Brown were noting earlier kind of how these types of things can happen and how you can have these types. And I believe it was Judge Currier that noted that there are ways in which this can be handled appropriately and limited. And the Scherer case is a case where counsel is right. It went on for well over 2 months, 9 weeks, because that judge did not place limits on the type of evidence that would come in a particular case. And so when you see those types of PowerPoints, that usually occurs when you have a judge that hasn't placed limits and hasn't given the appropriate jury instructions in those kinds of cases. The Carlson case, conversely, is a case where you have a judge that imposes time limits, that imposes limitation on the evidence and provides jury instructions. So there can be situations that I address. Now, I can't tell you because I don't have the PowerPoint in front of me as to, how far bar lawyers push that versus how much the plaintiff or the court allowed that evidence to come in, and then the PowerPoint was just responding to the evidence that the judge let in that particular case. But the bottom line is that this evidence is relevant and should come in. Now, the question of how much the evidence should come in, depends upon the particular case and the issues in the particular case and what the judge believes is important for the jury to hear based upon the claims that are at issue under the substantive law and how that relates to the particular issues as to that device or as to that particular plaintiff.
Stopping here for a moment, thank you. Does your organization and the three amici, do they endorse the caveat that Mr. Kott led with, which was, and if this evidence of 510K clearance is presented, the jury can also be informed by the plaintiff that there were, in this case in particular, modifications required by the FDA, and that that the plaintiff would be able to show that what the company tried to get the FDA to clear originally was found to be unsatisfactory. Could that side of the story appropriately be provided? Do you agree with the concession that he made as part of his presentation in terms of a proffer?
Yes, Your Honor. I generally agree with one exception or one caveat, which is the Buckman case from the United States Supreme Court that prevents somebody from arguing that somebody defrauded the FDA. Right, so there would be limits on an argument to say that you're not allowed to argue to the jury that the manufacturer did something that was, obtained a clearance through fraud on the FDA. Right, that there are limits on that particular thing. Right, but generally about how the FDA, addressed an application and its determinations and those types of things, I think, opening the door to certain scenarios that the plaintiff might. You would have different circumstances in every case, but I do believe that evidence could be relevant in certain circumstances, yes.
All right. Last question I have for you. On page 16, again, coming back to the response to your amici presentation, I asked Mr. Kott about this. Is it true that the application here was a subsection A1 and not an A2?
Well,
this is your brief.
I'm trying to follow.
To your, are you Avamed? Wait a minute, maybe I've aligned you with.
Yes, Your
Counsel
Honor.
for Avamed? Yeah. So
yeah.
Is what he says on page 16 of his brief correct? That this is not a subsection 2, where the clearance requires there has to be at least as safe and effective, et cetera. That you try, in this case, the defendant tried to get it under the other subsection that simply looked at the similarity of technological characteristics.
Yeah, I'm not following exactly what the argument is, Your Honor, and I apologize that I haven't read that brief, the page 16 of that brief, and my computer issues have prevented me from bringing it up, but I can't tell you that.
That's fine. It's not the point of today. All right. Do we have any further questions of amicus from Judge Gooden Brown?
No, Judge.
Judge Currier, anything you want to ask?
No, thank you.
All right. Anything you want to say by way of wrapping up, Mr. Rogers? And we have been able to cope with your sound issue, so we've been able to hear it. Go ahead.
My great apologies, Your Honor, about my technological issues today. We would ask, that you respect the judgment of the North Carolina and the New Jersey legislatures that have appropriately created the balance that this type of evidence is admissible in these types of proceedings and allow it to be given due weight by a jury. Thank you.
Thank you. All right. Mr. Slater, you've been patiently waiting to respond to these points, and now it's your turn.
Thank you, Your Honor. I'm going to try to hit these seriatim. The first thing that I will just say again is that this is an abuse of discretion case, and I think that our most poignant request is that this court credit the discretion exercised by the judges managing the consolidated litigations of pelvic mesh, Judge Hars, Judge DeLuca, Judge Goodwin, and the judges in Philadelphia who have been affirmed up to the Pennsylvania Supreme Court on this issue in the Carlino decision, actually through the Appellate division in Carlino. So that's to me the place to start. Now, Your Honor's asked a few times about whether or not the modifications requested by the FDA could come in. I want the court to know those were insignificant, minor modifications that had to do, I think, with how long somebody should refrain from activity or something like that. They were not substantive. They were not of any significance, and those were not parts of the warnings that were ever at issue in the trial because they were so insignificant. So that wouldn't really help us. What the defense wants is they want their foot in the door because they know that once they get the 510K in and the FDA is in the case, everything will be put through the prism of the FDA. Every single witness, every single bit of testimony, the treating doctors will be asked about their awareness of 510K clearance through the FDA, the experts, the fact witnesses for the companies, everybody. It will be the theme of the trial because that's how these cases work. The Shearer case was tried, and that's how the case would be tried.
Well, a good plaintiff's lawyer wouldn't let that happen. You would be complaining mightily about a skewed PowerPoint that equates substantial equivalence to safe and effective. You would be making objections left and right, and a judge would have the authority to grant you relief if they were overdoing it.
But the reality of it is,
why is it enough to have a good advocate help regulate what exactly the jury is entitled to know and where it's being abused?
Because at the end of the day, if you look at the limiting instruction again from Weinbarger and the limiting instructions in the IBC filter cases, they basically are telling the jury, disregard everything you're hearing. So the jury is told you're going to hear this, but it doesn't matter. And it's impossible for a jury to deal with that. So I'll give you an example from the McGinnis case. I lost them in limiting motion. Bard kept out that the product was off the market. And I said, well, Judge, if they talk in the present tense, he said, it's coming in. I must have objected 15 or 20 times during the trial. I said, Judge, and he said, next time. It never came in. But we were at sidebar maybe 15 or 20 times during the trial over this. So my experience is it's not going to matter. The point is it's a consideration, it has to be dealt with. Now, they're acting as if the 510K process is a problem. The 510K process was a boon for manufacturers. And in fact, Advamed, who's appearing on this, brought the pelvic mesh manufacturers' representatives to Washington in September 2011 when there was a panel conducted to look at the safety of pelvic mesh, whether they should reclassify it, which led to 522 studies being ordered by the FDA, following which some of these products went off the market after they tried to get the FDA to accept the studies they had done when they were now converting to high-risk devices under Class 3. By the way, all this would come in during the trial. So it's not so simple. It's not a couple of simple experts talking about a couple checklists. This would be the theme of the case. Then there's the 2008 public health notification. Then there's the 2011 public health notification. Then there's all the other FDA notifications and things that they've put out. So you're talking about a massive amount of data. Now, let me correct one thing, because there's a lot of issues to address. Number one, this idea of deferring to the North Carolina judge, that's not the law. He's a federal judge. And by the way, the federal court that sits above him in the Sisson case, the Fourth Circuit, rejected this position and rejected it in Husky. So several times they've rejected the finding by that lone North Carolina judge with a mystifying decision.
Sisson wasn't applying North Carolina law, was it? Or am I wrong about that?
Sisson applied Georgia law, which had a very similar and actually even better statute for the defense than North Carolina. In Georgia, it was any regulatory compliance as opposed to government standards, and that was kept out under the Georgia statute. And Sisson, they said it doesn't come in. So the judges who sit above the judge in the Weinbarger case, they said, no way, this isn't coming in. So I don't.
Courier, I'm sorry, I cut you off.
I just want to make sure I'm hearing Mr. Slater correctly. First of all, in your first go around, you quoted to us that Judge DeLuca considered a limiting instruction, but he did not. You were actually quoting Sisson and Judge Goodwin and other cases. He never said in his 2-page ruling that he had considered a limiting instruction, right?
No, I believe that he did actually.
Where do you see that?
It's on page 16 of my brief. There's a quote. I believe that was Judge DeLuca ruling, because he talks about, on the one hand, the jury's being told it is not a government standard, while at the same time having Bard argue it complied with the 510K process. I believe that was Judge DeLuca's ruling, and I know that was the rationalization. He ruled that
What page? I'm looking at the transcript itself. So
13?
Where does your quote come from?
Yeah, I'm looking at 13. Is that where you are, Judge Currier? That's page 13? Yeah.
We cited to DA 2258. So that's the best I can tell you. I believe that's either the transcript or it's his written decision, or I mean I can find out and obviously get it. But
so
that's the citation.
Throughout his decision, he's just stating what other courts have said.
I don't believe so, Judge. I think he made an independent decision, but he did it obviously taking into account what a lot of very respected courts, including the courts of appeals of 2 different circuit courts, overseeing the pelvic mesh MDL of over 100,000 cases, had ruled on. So I think that he was allowed to make these rulings.
He said at he never, but I thought you told us that he considered a limiting instruction. That's nowhere in his decision. He did say at the end, I think what you quoted from is that even if I found that there was some probative value, the probative value was substantially outweighed by the prejudice and confusion. Those were his own. That's really his only finding. And he also found, of course, it wasn't a government standard under the North Carolina law. But I didn't see anywhere that he considered a limiting instruction. I just wanted to see that we were, on the same page.
I think he did, Judge. Respectfully, I think he did, and I think that's where that language comes from. It's either him saying it, and now I thought it was him saying it for every moment, but now when you ask the question, or him citing it for support for not giving a limiting instruction, because the reality is in the pelvic mesh cases, it would be too complex. It would hijack the case, and that's what will happen if this comes in.
Okay, and I just want to ask you one other question. I understand that your argument on that. So a lot of the judges and you have hung your hat on Judge Goodwin's initial ruling on this, right? You've just mentioned he's handled thousands of these cases, and then the Fourth Circuit in Sisson. But when you read Sisson, they found the Fourth Circuit found that the district court, meaning Judge Goodwin, was entitled to put 510 evidence before the jury, but it was not obligated to do so. So the Fourth Circuit has only ruled on not overruling the judge's discretionary decision. There's nobody who's given a stamp of authority that it absolutely can't come in, right? They just affirmed his decision, that his discretionary ruling on the evidence. Oh,
absolutely. I agree.
Okay.
I agree.
I just wanted to make sure we were in the same page there. And I want to make sure I haven't missed something else. Did either judge make if it's a discretionary ruling, evidentiary ruling, did either Judge Hars or Judge DeLuca make a analysis other than just a statement, but did either go through 403, telling us why it's probative, not probative, and then other than just saying it would be confusing, it would be misleading?
Well, I think that certainly, Judge, I don't have both the decisions right in front of me, but I know that certainly Judge Hars analyzed what is 510K versus PMA, and that was, I think, the core of her decision was that it's so attenuated that it's just going to be it'll be too difficult and it'll be too much of a sideshow to put it in when it's not PMA, which are obviously handled much different in New Jersey.
Okay, so more of a relevance argument on her end, or
my feeling from the trial, what I believe happened at the trial, and I was there, was the relevance was so attenuated that the judge found there's no reason to put it in because of the other factors outweighing it, that it would be such a focus of the trial. And Judge DeLuca went into more detail in his rulings, as I've submitted in the brief. He actually, on the record and in some of his decisions, has explicitly gone through that, and that's where he went through the limiting instruction issue.
why is it fair, Mr. Slater, apart from the argument that it's compelled to come in, but looking at the fairness of the trial, you don't deny that your side repeatedly reminded the jury that the manufacturer never bothered to do any clinical trials. It was said over and over. True?
Oh, yes.
Yeah, okay, that was a major theme. Why is it fair to not let the jury be made aware that the government didn't require it with an appropriate limiting structure?
Because that'd be so incredibly misleading. It would be unbelievably prejudicial, because what the government did or didn't make them do, I read it to you before, had nothing to do with evaluating whether a safety study was needed in order to evaluate safety. So it would be completely misleading to tell the jury we didn't do a study, which they told you in the proffers, which are in my briefs. We want to tell the jury we didn't need to it because the FDA didn't think we needed it to prove it's a safe product. And that's not what the FDA looked at. I read to you, they just said in one line, we don't need a clinical study to determine substantial equivalence. They were allowed to, and this, I'm glad you asked this question. Ford and Ethicon were both allowed to put their entire defense on. Their defense to no clinical studies was, we didn't need to do a clinical study because other products or other systems had been studied, and we had that data from the literature, and we had other testing that was benchtop testing in animal, and we relied on that, and that was sufficient. They would say exactly the same thing if the FDA was there, except that they would cloak it in, and the FDA said that was fine to make sure it's a safe product every single time they mentioned something. Every question would be, and did the FDA take issue with that? No. And did the FDA take issue with that? No. Because this isn't PMA. It's so different. It would be so misleading, and that's what the courts of appeals found in looking at the weighing decision under 403 in all of these cases, and said, looking at Lohr and Regal, and by the way, the Safe Medical Devices Act that Mr. Kott cited, that's a red herring because Regal came after that, Husky comes after that, all those courts came after it. In fact, in Sisson, they rejected the FDA's position that this is a safety regulation. They said that's self-serving, we don't have to follow, we don't believe it, you're wrong, and all of the courts of appeals have found it's not a safety regulation. So that's what the courts of appeals in the federal courts, which I think deserve some deference on that question, have said. In CV, the case cited from Judge Kugler, the whole point of it is the plaintiff didn't object to calling the product approved. So the issue was never raised. It was a plaintiff who didn't know the difference. There's nothing that they weren't allowed to do. They were able to put all their witnesses on in both cases, present all the medical literature, explain why they did studies. And by the way, I'm glad that this jogged my memory. Ms. Kabash said that they did the study, the quote-unquote TVM study, for 510K clearance. That's outright not true. They did the TVM study in 2004 and 2005. At the same time, they decided not to seek 510K clearance for the ProLift. They sold the product for over 2 years without 510K clearance. Then when they sought clearance for the ProLift M with that Ultra Pro mesh in it, the partially absorbable, larger, pore, lighter weight mesh, they put the ProLift on as the predicate to the ProLift M, and the FDA said, what's the ProLift? We don't have that product on our list. And they said, oh, that's a product we've been selling without 510K for 2 years. The FDA said, oh, okay, then just do the applications together. No harm, no foul. So then Ethicon submitted what they had because the study had already been done. They didn't need it to get to 510K. They submitted it. So that was very misleading, and I want to make sure the court knows that. Okay, I think I've done enough on 510K. I really think I should address a couple of the other issues if I need to. Certainly the statutory issue on the Punitive Damage Act.
Yes, please get there now. Thank you.
That's been looked at by multiple courts, and they've all found that the products that we're talking about here were neither licensed, approved, or generally recognized as safe and effective. And as on page 31 of my brief, we showed the rest of the legislative history because all that Bard cited was the part that says regulated by the FDA. A little later in the regulatory history, it says certain products that are regulated by the FDA. The definitions are very clear, and the statutory language cited on page 47 of Bard's brief, where they actually cite to 58C-5, the reason that drug, device, food, and food additive are modified at the bottom is because the terms pre-market approval and licensure are modified right in the body. It says pre-market approval or licensure by the Federal Food and Drug Administration under the Federal Food, Drug, and Cosmetic Act, and then gives the statutory sections to look to. It does the same thing for generally recognized as safe and effective. Those four words at the top were hanging out there, so the legislature modified them and said, oh, they also get to be modified according to what the Food, Drug, and Cosmetic Act says. So there's nothing that's untoward about that. With regard to another thing, you were told by Mr. Kott that there's a charge on FDA evidence, and it's easy to handle. Well, that charge is for FDA-approved warnings and instructions for PMA products. That's 5.40D4 subsection 2. And Mr. Kott told you that drugs don't go through and don't get PMA. That's just not correct. Otherwise, the presumption of adequacy wouldn't apply to all the drugs. And Accutane, which was just decided by the Supreme Court a few years ago, wouldn't have addressed the presumption of adequacy in the context of a pre-market approved drug that went through multiple clinical trials, which is a requirement to get PMA. So drugs do go through PMA, and that's why they get this special defense for the presumption of adequacy, and that's why they're mentioned in the Punitive Damage Act. In terms of the statutory issue in North Carolina, we cited the DeWitt case in our brief, DEWITT, where the Supreme Court of North Carolina specifically said that these factors may not all be relevant to a particular plaintiff's claim. So it's a decision made by the judge as to whether to charge those factors. That's the Supreme Court of North Carolina that says that. And ultimately, even if something is deemed relevant, it's subject to a 403 analysis in any case. So that would also be addressed. And in this context, you know, the Supreme Court case of McGinnis, MCCOMISH, 42 NJ 274, was cited by defense counsel to give the impression that in New Jersey, all regulations come in, all standards come in. Well, in that case, the standards were safety standards in a construction case that actually laid out the standard of care that was relied on both sides by the experts who were fighting about whether or not this construction site was safe, which is not the 510K process, which gives no specific standard for how to do anything other than show that you're substantially equivalent. There's a ton of other issues in this case, obviously, and I don't know where to even start in terms of the damages that have been challenged. I would, certainly say that Mary McGinnis, her injuries speak for themselves, I think, on this record. She has burning, chronic, disabling, devastating nerve pain in her vagina for the rest of her life. She's dealt with it for over 10 years now. She can't have intercourse. She can't hug her husband. She's in pain all the time. She has to put ice packs between her legs to sleep. She's been through multiple operations, including the complete reconstruction of her vagina, which is now completely, it pains me to say about my client, but it's a non-functional vagina. It is horribly scarred. It is horribly painful. Her husband, Tom, had to leave his retirement, basically, and go back to work full-time to help run their daycare center. And they've been through a tremendous ordeal, and it goes on every single day. And to the extent that these damages have been challenged, I would just ask that the court, again, just look at the recent precedent and realize this jury heard them, heard what was happening, heard what they were through, saw the evidence, and I think that these verdicts for Tom and Mary, though substantial, reflect injuries that you don't see very often, and of a level of personal nature and chronic burning pain to live with every day for the rest of your life. I think it's within what's reasonable.
What's the status of the other cases right now in New Jersey, Mr. Slater?
A large number of them have settled. The numbers of cases are down. The last conversation I had in connection with our last case management conference with Judge Hars on Ethicon is that the expectation is there's under 1,000 cases left once they get the list down, because people will settle and it takes time for that to trickle in to get dismissals.
Are the parties waiting for this appeal to be resolved before they start another trial?
No.
Okay.
Things have been shut down by COVID, frankly. There were
oh, right. Oh, of course.
Off, and
I actually forgot about COVID for a little bit. How about that?
Comforting.
Yeah.
I look forward to getting it someday. One other issue.
Go ahead. Yeah. Why don't you hit that point, and then we'll see if there's any more questions for you. Go ahead.
To the extent that the points about Dr. Gray, the chiropractor, are relevant, the transcript is very clear that Dr. Gray, when she testified about Mary McGinnis, she was her chiropractor. She was testifying to what was in her actual notes as her treating chiropractor, and obviously under the case law, she's allowed to provide that testimony that things
you're relying on Stigliano, right?
And Afram versus Heller, which goes directly to chiropractors.
Right.
And again, her testimony that touched on Ms. McGinnis's vaginal issues was directly from her own medical records, where she said that this is what's happening, this is how it's impacting her. Since the defense in the case was she has nothing wrong with her. That has to do with our product. She has a hip arthritis condition, and that's causing all the vaginal pain. And they brought in 2 orthopedists from Emory University in Georgia to come in and say that. So the treater who was actually treating her osteoarthritic issues was able to say she never had these problems until the mesh came in, and I can tell you how it affected her. These were the observations of her treater, which that could never be kept out because it was in her medical records.
Judge Currier, anything else you want to ask Mr. Slater?
No, thank you.
Judge Gooden-Brown, anything else you would like to ask?
No, thank you, Judge.
All right, Mr. Slater, anything further at this point before we hear from Mr. Kott on rebuttal?
Can I have any rebuttal?
That wasn't planned.
I understand. I don't have anything else right now, and I think
I think what you said a few moments ago is we could spend hours and hours continuing to talk about this. I think everybody recognizes that. So with that warning in mind, Mr. Kott, you have an opportunity to rebut.
Sure. First, on what's in the record, the FDA specifically concluded that clinical testing was not required. That's at our appendix for a line, page 2563, and for a Volta 2717. The FDA expressly found that the products were safe and effective. That for a line is at 2569, 2570. For a Volta, it's 2728, 2732, and 2733. Next.
Hold on. No, wait a minute. This is transcript, or are these documents from the FDA saying?
These are the FDA's own documents, not Bard's documents.
Okay. All right. Thank you. All right.
Next, on the 3 Court of Appeals, when you read those decisions, and the district courts and the lower courts, they don't have this record, where the plaintiff 23 times in this case and however many times in Heimrock talked about the lack of clinical testing. They don't have this record, the plaintiff offered the testimony of the treating physician on ethics and on being deceived. And when you look at those cases, many of the arguments that are made here by the defendant and in Ethicon, in that case as well, were never made in those decisions. So and I'm going to use courthouse talk, the defendants have learned and their arguments have evolved. And when the defendants have made the arguments that are made here, then the courts have adopted them. And I'm, of course, talking about the Bard IVC filters. I'm talking about the Cook MDL. I'm talking about the Keene case out of Pennsylvania. On the question, well, let me phrase it this way. Mr. Slater talked about all the proofs we put in to show that we didn't need to do clinical testing. I think what he's saying is harmless error. And I know there's a lot of issues in this case, and I know the issues can be analyzed a different way. But I don't think any of the 3 of you can do, and I know you can do whatever you want. You've both been appointed by the governor 2 times. You've all been confirmed by the New Jersey Senate 2 times. But as a matter of jurisprudence, on this record, I don't think anybody can say it's harmless error. On damages, the liability rulings not allowing us to defend on clinical trials and on Dr. Barbie's testing infected the damages verdict. And this court is well aware of Fertil versus St. Michael's, Penasir versus St. Barnabas. When the liability rulings infect damages, there needs to be a reversal on damages as well. Here, it's clear the compensatory damages, including $10 million for Mr. McGinnis. We had a jury that got angry at Bard in the compensatory stage. They got angry because of the clinical trials and Dr. Barbie's testimony. On punitives, we're looking at a $35 million verdict which I believe a near certainty would have been less if the jury had heard our side of the story. Finally, and finally, and finally. In our brief, we said something. In an oral argument, I don't often repeat what's in the briefs, but it's worth saying here. About 25 years ago, the United States Supreme Court said, a defendant is not entitled to a perfect trial, but a defendant is entitled to a fair trial. We didn't get a perfect trial for sure, and it should be reversed for all the reasons I've said, including cumulative error. But in our view, nobody can fairly look at this record and say that Bard received a fair trial. So we ask that this court reverse the judgment.
Judge Currier, Judge Gooden-Brown, anything further you would like to ask?
Not me.
Nothing further. Thank you, Judge.
Mr. Slater, 1 minute. You got it.
Oh, gosh, I wasn't ready. I thought I wasn't getting the time, Judge.
Well, you know, I turned you down before. Is there anything vital that we need to know, or are you prepared to submit as well?
I'll take the minute, and I'll try to talk at a reasonable speed limit. 510K coming in, all it's going to do is mercilessly complicate one of these trials. It's going to make it so that we are constantly having to answer what's the significance of 510K. There's no limiting instruction that's going to change that. Once that's in the trial, it's in the trial, and you have the proffers in these papers that show what they, on the defense side, wanted to say and what they will say, and there's no way to control that with a limiting instruction, and so you'll have a confused jury being told, you're going to hear this evidence, it doesn't mean anything for the questions you're going to answer as a jury, and the jurors are going to say, why are we hearing this? Because that's all they're talking about in this courtroom. There's no way to avoid that. There's no time limits because there's no limiting instruction. There's no way to keep the jurors from wondering, and you're going to have jurors who are going to be infected by that, and they're going to be considering 510K as a defense on the safety issues when it simply doesn't apply to that. Thank you.
Thank you. Well, I want to congratulate all counsel. Had a long day, a lot to think about. Case was marvelously briefed. We don't invite any more paper or electronic paper from any of you. I think we have what we need to ponder our decision here with the benefit of what you've all presented today. I appreciate the fact that the defense counsel and amici coordinated themselves efficiently. I appreciate the fact that Mr. Slater weathered through two back-to-back heavy arguments and a long day. You've all provided, and for the law clerks and law students who are watching, a very fine example of the quality of advocacy that takes place in the highest tradition of the New Jersey court. So you should walk away, win, lose, or draw today, feeling that you did the best job possible for your clients. We appreciate that. We wish you and your families good health during this very difficult time, and we look forward to seeing you together in the months ahead. But in the meantime, we take the matter under advisement, and this matter is concluded for now. Thank you all.
Thank you, Your Honor. Thank you, Judge.
Thank you.
Be safe.
Judge.